Sir, in the back. I know you remembered your question.
Constitution. I'm no expert, but I've read it.
Okay.
Nowhere in it is the word diversity. Nowhere in it is there any reference to religious, ethnic, or racial groups, other than in the negative when you get to what, the 16th Amendment?
Well, you do have the First Amendment that says there shall be no, the separation of church and state says there shall be no law prohibiting the free exercise of any person's individual religion.
But it doesn't refer to treatment of groups. It refers only to treatment of individual persons and citizens and such.
Well, that's absolutely right, though don't forget the 14th Amendment's equal protection clause, which says that to treat anyone differently because of their religion would, in fact, violate the Constitution.
That's right. But when you pursue an affirmative action policy, you're not treating you're treating this one different than that one. You know, there's two sides. If Baki was denied admission to the medical school in California, somebody else got it. You know what I mean?
I do.
And Baki is a person too. He has feelings and such, which
that's certainly true.
Judges don't seem to understand.
Well, I don't really disagree with anything that you just said. I think I agree with everything that you just said. As you know, the Supreme Court has heard a number of cases about affirmative action. It's a very complicated area where they've said under certain circumstances you can consider race as one of many factors. Under certain circumstances you can't. Just a few years ago, gosh, I guess it was about 4 or 5 years ago now, they heard 2 cases coming out of Michigan, one from the law school and one from the university, the undergraduate, and they said one, the affirmative action was no good, and the other, it was okay.
Ridiculous.
So it's certainly, there are no clear lines in that area, and I think certainly...
And they killed a young lady's career at the University of Michigan.
Well,
they broke her heart.
Well, and the woman I think you're talking about won her case. So it took a while.
Like 5 years later.
It took a while, but that was thrown out. But I think reasonable minds disagree about this, as with many other issues. And
see from what that gentleman raised before, the city of New Haven said, "Hey, we don't want to be sued by the NAACP, the ACLU, this and that," but they got sued by the white firemen. There's two sides. So
well, and you're damned if you do, and you're damned if you don't, I suppose.
Was choosing a side.
Well, I think they had to.
Could you delve into the Missouri position? You were saying that I think there's a vetting committee. Could you delve into
The Missouri plan for judicial selection? Sure. The Missouri plan involves a commission, a nominating commission, called a merit commission frequently, and they select, well, they don't select, they review applications for the openings on the bench. By way of sort of background, when all the just going back historically, when all the states were admitted into the Union, none of them had judicial elections. They all essentially had basically a form of what the federal government does, where the governor would appoint. And there was a concern in the early 19th century, the 1800s, that the political machines like Tammany Hall in New York and these sorts of political machines were just controlling the bench. And the concern there was that these political machines got to decide who was a judge, and then it was just an extension of their power. So during the Jacksonian sort of populist period, a number of states went to elections. They thought, we've got to wrest control away from the political machines, give it directly to the people. So they did that. Unfortunately, then a number of states decided that wasn't working too well because the political parties were just controlling the elections, and they thought, we didn't solve the problem we had perceived initially. And so a number of states looked at different ways of doing it, and Missouri was the first to come up with this sort of hybrid plan. The way the Missouri plan works, and that's been implemented in, well, it depends what court you're looking at. There are 34 states that have some sort of a nominating commission at some level of the judiciary. Many states, for example, will have appointments of the Supreme Court, but then popular elections for the trial court. So many states have some appointment system and some election system. At any rate, the system that is referred to as the Missouri Plan involves a commission that in different states has different component members. Some states reserve a certain number of for members that are appointed by the Bar Association, so basically lawyers, and a certain number for non-lawyers that the governor or the legislature will appoint. There are different formulas. There are different types of commissions. Some have 7 seats. Some have 10 seats. The state of Tennessee just changed their nominating commission earlier this year because of concerns that the trial lawyers had too much power in it. So the actual constitution of those commissions varies a little bit from state to state, but the basic idea is that what you have is a group that's ideally at least designed not to be controlled by one of the political parties, not designed to be partisan, that will review applications from anyone who wants to apply to a judgeship. Now, usually, the only people who are invited to apply to be judges are lawyers, though perhaps that might not be true everywhere. And they fill out their applications, and the commission then is supposed to come up with, in effect, a short list. In some states, it's at least 2 names. In some states, it's 3 or more. But the idea is that they go through all the applications, and they select who they think are the most qualified. And they look at record of public service, educational credentials, involvement in public policy making, what their career as a litigator or as a business lawyer has been, all of those kinds of things. And they are then select a certain number of candidates, which they forward to the governor, and then the governor is generally obligated by law to choose one. I think there may be states where the governor can take a pass and send it back, give me more names. But in many states, at least, the governor is obligated to choose one of the names. And then again, exactly what happens to that judge varies a bit from state to state. Generally, the way it works is that judge is appointed to the bench and a number of years pass, and either at the next general election, the next federal election, or in 3 years, something like that, that judge then stands for a retention election. And it's an up or down vote. And the public has an opportunity to say, based on your track record as a judge, we either want you to stay or we don't. And those elections are, in some cases, similar to some of the problems we see in contested elections, which is to say that sometimes there are outside groups that come in from out of state and run particular ads if a judge is perceived as being hostile to the trial lawyer agenda or the big business agenda. So there are those who say that those retention elections are not perfect either. But I think by and large, folks that look at this, I think many think that this is an effective system. I think, as I mentioned earlier, I think it's unlikely too many states that have elections now are going to throw the elections out and go to this system. And there are those who don't like these systems because they feel like it's in the pockets of the trial lawyers, or it just enables the governor to choose who he or she wants. But I think Missouri's experience and the experience of the other states that have these systems in place is that they can help to neutralize some of the really virulent partisan negativity and select highly qualified judges. Yeah.
Are those elections held in conjunction with the general election, or are they special elections?
Those retention elections I talked about, I think it varies a little bit. I mean, I think in some states it'll just be one more race on the ballot, and then in other states it may be a special election that they have just for that purpose. Ma'am?
I think you point out when you said Justice Sotomayor is only the 3rd woman to go on the court. I think you need to realize until the 1920s, women could not vote. So, I mean, we certainly had to catch up. It's about time we did. But, again, women were not out in the business world until after World War II. In World War II, they stepped in to replace the men in business and factories and worked. They never went back. And that's when I think women really started to go into law professions and anything else.
Mm-hmm. Well, don't forget that the very first woman to serve on the U.S. Supreme Court, Sandra Day O'Connor, when she graduated at the top of her class from Stanford Law School, couldn't get a job because no one would hire a woman. And a couple of firms offered her a job as a secretary. Now, obviously, she had an incredible career and was the first woman on the bench, so that's certainly absolutely right. And I think that the incredible strides that women have made just in their representation and the numbers in the law school and the numbers in the professions, you look at partners in law firms and so forth, suggest that certainly there will be increasing representation on all levels of the bench at the Supreme Court level and the courts below that. But it has taken some time, certainly.
And a black couldn't go to Rutgers either.
Well, that's absolutely right. And so I think, society